Good morning. Thank you, Kevin. I'm going to swiftly follow on to examine some of the problems that Antoine alluded to in terms of structural problems that we've seen have existed for a specific number of time in several of the member states, and we seem that we've worked with at the clinic for quite a while. Seems to be a little problem with the okay, very good. So, as a starting point, we can tell that we can see that the European Commission has been examining this issue for several years now. In its first report, which was published in 2008, about the state of implementation of the Directive on Free Movement Rights, Directive 2004/38, the Commission noted that not one member state had transposed the directive effectively and correctly in its entirety, and not a single article of the directive had been correctly implemented in all of the member states. In its follow-up citizenship reports in following years, the Commission reported on the active enforcement policy which it was pursuing against several member states, and at the moment basically there are a number of open infringement cases against several member states. Those are the case infringement numbers in brackets, and 4 cases have been closed by the Commission at the end of 2013. All of those cases were opened around June of 2011, and we can see the majority of the cases are still open. And I'm going to speak about some of the details. I don't know what I've done.
The center.
Yes, I'm doing that. Okay,
like
very
that.
good.
Yeah,
All right. If we look at the state of transposition in several member states, we can see that. I need to go back. I'm sorry, I'm not doing a very good job of this. I'm not used to this. Can we just go back a couple of slides? Sorry. I was being the one before, and one more, sorry, one more back. That one. This is a little chart that I put together that combines information that's been processed out of the Commission's reports on the state of transposition of the directive, and a follow-up 2013 report that we did on the state of transposition. And that gives you a little idea of how member states fare in terms of transposition and application, or the practical implementation of the rules. And we're going to look at specifically some of the member states that don't fare so well: Belgium, Sweden, and the UK. Particularly in Sweden, a long-lasting problem has been the personnummer. The personnummer is basically a personal identification number which features on all Swedish and EU citizens' identity cards, and it's there to basically provide confirmation of a person's unique existence. It is compulsory for doing pretty much anything that relates to leading a normal life in Sweden, from renting accommodation to registering for a job to signing up for free language classes to also opening a bank account or getting a mobile phone or an internet. So basically, without your personnummer, you cannot lead a normal life in Sweden, because you'll be frozen out of both accessing public services and private services as well. The source of the problem is Section 3 of the Swedish Population Register law, which basically states that when somebody moves to Sweden, they have to register on the population register if they are able to demonstrate that they're going to be spending at least a year in Sweden. And that's the source of the problem, because if, as a typical example that we get, somebody moves to Sweden with a short-term contract that is less than a year, the Swedish tax authority, the Skatteverket, will not will not allow that person to obtain a personnummer, because they say the law requires you to demonstrate that you're going to be here for more than a year, and if you only have a fixed-term contract of, say, 6 months, then we have no certainty that you're going to stay in Sweden, and therefore you won't be able to get your personnummer. This is what's basically stopping people from being able to get the personnummer, the fact that they are unable to demonstrate that they're going to be residing in Sweden for a year or more. And it's affecting not just people on fixed-term work, but also job seekers, students who might be there for a short Erasmus exchange program, and they won't be able to register and get a personnummer. Homemakers, those are husbands or wives who stay at home and to take care of the household while the other spouse is working. Pensioners as well, who might not necessarily have health care, and also people in pre-retirement. That is the various categories of European citizens who basically are being excluded by the Swedish administrative practice on the issue of the personnummer. When we look at taking from the advice from your Europe Advice inquiries, just to give us an idea of a feel for the extent of the problem, we can see that in terms of issues relating to residents have crept up quite a bit in this year. And when we look at the number of cases of relating to inquiries of on the personnummer as a proportion of the total residence inquiries for Sweden, we can see that in the last 3 years it's been quite a substantial number, over 80% in 2015, now down to still over 50%, which represents still double the number of inquiries compared to 5 years ago. What we're doing with the clinic at the moment is we've received quite a few complaints from citizens who've been affected. We're currently working on reviewing their complaints to put together a complaint to the European Commission and petition to the European Parliament that explains why this is a problem and why the European institutions should take further action. We are recommending in this respect that the Commission should basically launch infringement proceedings against Sweden, because even though this issue has been addressed by the Commission in the EU pilot scheme, which provides for talks between the national authorities and the European Commission, unfortunately we haven't seen any resolution, because all we see is the Swedish authorities promising that they've addressed the rules, and they haven't done so. The problem is still there. Section 3 of the Swedish Population Register law is still there, and it's still the source of the problem. So basically, all it requires is just a change to the law to reduce that 1 year requirement to maybe 6 months, 3 months to keep it in compliance with the directive. That's all that's needed, really, to resolve this issue, in theory. Then if we look at the next structural problem, which relates to the United Kingdom, and the United Kingdom's policy relating to comprehensive sickness insurance. Under the Residence Directive, if you move to another country and you do not work, you are required to show that you have sufficient resources not to be a burden on the host country's social assistance system, and you're supposed to have comprehensive sickness insurance. Comprehensive sickness insurance is not defined by the directive, and in the Commission's guidelines on the issue, they say it can cover any form of healthcare, either public or private healthcare. The UK's policy on this has been revised over time, but it's been the same. Basically, reliance on the National Health Service, which is the public healthcare system in the UK, reliance on the NHS is not considered by the Home Office, which is the authority that's responsible for applying the immigration rules in the UK. Reliance on the NHS by EU citizens who do not work is not seen as constituting comprehensive sickness insurance for the purposes of the directive, as interpreted by the UK authorities, of course. And so they require, in effect, that people who don't work should have private healthcare to be able to meet the requirements for having comprehensive sickness insurance. This is despite the fact that, as a matter of UK law, anybody who is ordinarily resident in the United Kingdom is entitled to access the National Health Service. So anybody who's living for the time being in the UK should have access to the NHS. But the Home Office considers that if you rely on the NHS, you constitute a burden on the UK social assistance system. Now, there are questions about whether this is a correct interpretation, particularly because the Court of Justice seems to suggest that healthcare is not social assistance, but unfortunately there is no clear-cut case of the Court of Justice that has addressed this, because all attempts by individuals and civil society groups in the UK to try and get this issue referred to the Court of Justice in Luxembourg by the UK authorities have been stopped effectively by the UK Court of Appeal in the UK, which has consistently refused to refer the matter to the Court of Justice in Luxembourg. And this is a problem, also misinformation by the Home Office, saying that if you're an EU citizen and you don't work, you don't even have a right to access the NHS. And this is an example of the complaint that we have received at the clinic, complaining that the Home Office had informed them that they don't even have a right to claim treatment on the NHS, which is obviously not true. Typical complaints that we've seen is that people have not known about this requirement about comprehensive sickness insurance since moving to the UK. We've had complaints from far back as 2000 and more recently 2013. Basically, people don't know, and the only time that they realised this was through press reports following the Brexit referendum result, where people have started to being rejected for their permanent residence applications on the basis that they did not hold comprehensive sickness insurance in the UK. A typical case is the case of Paulus, who's a Latvian student whose Ethiopian wife actually works for the NHS. This is a true case that we have used. Obviously, the names have been changed and nationalities as well to protect the innocent, as it were. This student was refused a permanent residence card because he had not held comprehensive sickness insurance while a student. He had worked for a bit, then become a student, then worked again, and he'd been there with his wife for 9 years. So the UK authorities didn't even take into account the fact that him and his wife jointly contributed over £35,000, which before the Brexit that was about 50,000 euros, over their course of their residence in the UK through income tax and social security contributions. That was deemed irrelevant to the purposes of deeming whether Paulus was a burden on social assistance for not having had comprehensive sickness insurance. Completely ignored. In the end, through our intervention, we were able to identify a transitional policy that because Paulus came to the UK before 2011, had held a registration certificate. EU students who held a registration certificate before June 2011 were able to be exempted from the requirement to hold a comprehensive sickness insurance. Now, why is it that people have told us that they didn't know about this requirement? When you go on the website for the Home Office, that talks about how do you apply for a registration certificate to prove your right of residence in the UK. First, it says you don't need a document, and secondly, it says it talks about people being qualified if you're working, studying, self-employed, or self-sufficient, or looking for work. There's absolutely no information there whatsoever that if you don't work, you need comprehensive sickness insurance. There's no link to explain what amounts to comprehensive sickness insurance, and it's only if you dig into the guidance that's issued to the Home Office caseworkers that you actually get to identify what is the policy of the UK on comprehensive sickness insurance. So what's the problem there is that this policy is excluding anybody who doesn't work. So students, homemakers, carers, persons in pre-retirement, and also workers who earn less than £157 per week, which the UK authorities consider are not workers under EU law because they do not engage in genuine and effective work. The £157 is the level of income that triggers national insurance contributions being payable in the UK. And the UK has used that as a level, so if you don't work on that, basically it's assumed you're not a worker for EU law, which is of course completely contrary to the established case law of the Court of Justice. If we look at, again, number of inquiries, we can see that this issue, in terms of generally residents' rights, has increased your Europe advice. We have the Brexit effect. Before Brexit, residents' cases amounted to about 25% of cases. Now they amount for over 35% of inquiries to your Europe advice. And when we look at the issue specifically of comprehensive sickness insurance, we can see that it's dramatically increased compared to previous years, because people are saying, either I've applied and been rejected for permanent residence because I don't hold comprehensive sickness insurance, or I don't bother to apply because I've been told that there's no point because it'll be rejected and I'll waste my £65 application fee. This is obviously creating a problem for people because they're worried. They have no security. What's going to happen to them? If you don't hold comprehensive sickness insurance, what's going to happen to me in 2 years' time, in March 2019, when the UK finally cuts its ties and free movement is no longer a reality in the UK? What's going to happen to them? So we're getting a lot of inquiries about people being worried about their situation. The group, the NGO, the 3 million in the UK, estimates that there are 1 million, that's 1/3 of the resident EU population of 3 million in the UK that is at risk of deportation. The 3 million get to this by looking at the latest statistics on rejection rates for applications for EU and EEA residence documents at the Home Office. It currently stands at about 30%, but this is down from a high of 40% in 2012. So we see it's been going up, but at least under this current government and the previous one, the same party has been in. Since then, rejection rates have dramatically increased compared to previous years. Now, this 1 million are at risk of deportation on the basis of a 30% rejection rate. So if we take 3 million EU citizens in the UK, 30% rejected, that leaves 1 million at risk of deportation. But there's another way of getting to that figure as well, which links to the comprehensive sickness insurance issue. If we consider there are over 3 million citizens who reside in the UK, and about 30% of them do not work, then that leaves a million EU citizens who should have comprehensive sickness insurance, and because they do not hold private healthcare insurance at the moment, because they don't know about it, then they're at risk of deportation from the UK. So this is a particularly significant issue. We are working on this. We hope to provide again a complaint to the European Commission asking for it to take action in its open infringement case against the UK on this particular issue. We hope the Commission is going to bring the UK government to court. It still can. It still has 2 years to do that before the Court of Justice. There is an emergency procedure that allows for quick processing of cases, and we would hope the Commission takes advantage of that to make sure that there is a judgment within the next 2 years. But that addresses with complete clarity what the rules are in this respect. Because it's not just the UK. This issue is cropped up in Sweden, it's cropped up in France, in Italy, in Spain, in different guises, but the healthcare issue is a particular problem in several member states. And most recently in Ireland, that seems to be replicating the policy of the UK when it comes to EU citizens there. One last issue I'd like to talk to you about, if I have time, is the expulsion of EU citizens from Belgium. You may remember a couple of years ago that it hit the headlines that 2,712 EU citizens had been expelled in the year 2013 by the Belgian authorities on the basis that they did not have a right of residence in Belgium. Now, the issues are no longer being reported in the press because, of course, figures have come down, but it's still a significant number of citizens, EU citizens, being faced with deportation from Belgium on the basis that they have been issued an order requiring them to leave Belgian territory because they do not have a right of residence here. And we're still, for the latest figures, we still have 1,702 citizens. The top five targets of these expulsion orders are Romanian citizens, Bulgarian citizens, Italian citizens, Spanish citizens, Dutch citizens. So not your usual suspects when it comes to expulsion measures compared to maybe other countries. This issue is a particular problem when it comes to appealing against an expulsion order. the Belgian authorities have put in a very restrictive appeals process that makes it almost impossible for EU citizens to be able to get a proper hearing of a measure against them. The specialized appeals court that was set up in 2006 is the Immigration Appeals Council, which basically is the authority responsible for all immigration appeals in Belgium, be it asylum cases, immigration cases, EU residence cases. And in EU residence cases, they operate what is called a control of legality. So when an appeal is brought against a decision of the national authorities, such as an expulsion measure, the court doesn't rehear the entire case from scratch and allow new evidence to be presented, etc., etc. No. Instead, they look at, administratively, have the rules, the procedures been followed, and has the law been applied in a reasonable way that doesn't display a manifest error of appreciation, which is the term that is used in administrative law. So they operate a control of legality, which is not the same thing as, say, in the UK, where the UK courts rehear the case from scratch and they can make a new decision. Belgium's courts can only do two things: uphold a decision or decide that the decision is unlawful and quash it and then return the matter to the immigration office. They do not have the right to remake a decision and basically recognize people's residence rights. And this is creating a problem. Because, for example, because of the way that the rules have been interpreted and principles of Belgian administrative law have been interpreted by the Belgian courts in the context of immigration appeals, no new evidence can be presented. And that was not presented before the immigration office. But the immigration office provides very little information about, for example, how do you prove, if you're a job seeker, that you have a genuine chance of being engaged. And we see that time and time again, this is a reason why job seekers in Belgium who come and who haven't found a job in 4 to 5 months usually get served with an expulsion order these days, because the Belgian authorities say, you haven't found a job in 5 months, this means you do not have a genuine chance of finding work in Belgium, please leave the country. And there's no way of challenging that assessment by presenting evidence that wasn't presented before the immigration office in an appeal. So that's one example of how this control of legality is creating problems. Another one is that the assessment made by the court as to the legality of a decision is made on the date the decision was made, but not the date the decision was actually notified to the person. And we've recently had a case where a Spanish lady was the subject of an expulsion decision that was made in 2011, and the immigration office waited 2 years before actually notifying this lady that she didn't have a right to work. And of course, other things had happened. She had worked during that time, but none of that could be presented to the courts because it was that change of circumstances happened between the date the decision was made and the date that she actually effectively got told to leave Belgium. And what happens in those two is not taken into account by the immigration courts. Another problem is that if, for example, you are a job seeker, you're looking for work, and you then don't find work within 6 months and you get an expulsion order, then you will obviously keep looking for work. You might not leave Belgium, you can stay here. If you make an appeal against that first expulsion order, and then you later find work, which allows you to stay, if you make the mistake of actually going to register and getting your residence card to show that you're allowed to live in Belgium, that will then be used to basically say your appeal is no longer admissible because you don't have an interest in continuing with the appeal. And this is a particular problem because it means that you can't safeguard any previous periods of residence that you've acquired in Belgium in the past. And obviously we know that to acquire permanent residence, you need to live 5 years. And to show those 5 years, you need to be able to do something to secure those rights. And if they're under challenge, you should be able to appeal against that challenge. And unfortunately, the Belgian immigration courts do not give that facility to EU citizens in Belgium. So there's significant problems with how the Belgian authorities basically handle appeals in Belgium. So I've given you an overview, hopefully, of some of the details of the structural problems which EU citizens continue to face in various European countries, and these are some of the cases that we're working at the EU Rights Clinic. Thank you very much.